Hello, everyone. Welcome to the webinar today. So glad to have you with us. If you can hear me and everything looks okay, please give me a shout out in the chat so I can make sure everything's functioning just fine. I am the speaker today, so I don't have any assistants with me. So welcome or hello in the chat would be really helpful here as well. Hi, Mike. Thank you, Mike. So as you all are coming in, just a quick brief introduction of myself. My name's Alexandra Alvarado, and I'm the Director of Marketing and Education at the American Apartment Owners Association. And today's webinar is sponsored by K Properties and Investments. So before I begin talking about our topic today, we are going to briefly just show you a little bit about K Properties here as we come in. Hi, Riza. Hi, Angelique. I'm going to go ahead and share my screen here so you all can see the video that I'm about to show you. And again, if you could tell me in the chat if you can hear it okay, that would be fantastic. Here we go.
You always answer the phone, you always respond, you're very kind, you're always fun.
It always feels good to feel like the only client and person in the world. And I got that feeling.
We've been very happy, and I really, really appreciate you.
You got to know us and understand what we were looking for.
And then we interviewed with you over the phone, and we said, you're it.
There was no high pressure, there was no hurry up and do it now, or you need to do it.
Your team, that's what keeps me coming back.
You folks, both you and other team members, have always been very responsive to me. You've been very helpful.
Would you guys feel like you would recommend K Properties to a friend?
Absolutely.
Yes.
I don't think there's any question that
Right, in a
we would.
heartbeat,
In a
yes.
heartbeat.
It's like learning a foreign language in a week. It's very hard, and we really appreciate you.
My name is Fred from Huntington Beach, California, and I'm happy to talk about K Properties in helping us select real estate investment.
Go on for hours
Funny.
on how wonderful it is to work with you, with K Properties.
No, honestly, how you explain things. So simple.
Definitely.
And sometimes I know I'd ask the same question 5 times, and you never got frustrated, or at least never showed it.
It was pure education, and we never felt pressured. It was, ask as many questions, we'll do as many Zooms as you want, we'll send you whatever you want. And sure enough, there'd be the prospectus, and all of our questions were answered. And I really love about K Properties, they have a bunch of educational material.
Yeah.
So happy. And I don't want to say that in past tense, because we're still going to have a relationship, and I'm sure I'm going to still have questions, and one day we're going to sell that other building.
I love about K Properties is because I can sit back, absorb all of the information I see in a PPM.
All positive experience.
We absolutely would refer you guys every time.
He has been very helpful, very courteous, and always gets back to us right away when we have questions and is concerned about what'll fit our needs best. Again, K Properties, we wouldn't hesitate to recommend them to anybody.
All right, so that was K Properties, our sponsor today. They do 1031 exchange and DST investments. And again, this is just before we start. If you could answer, if you'd like to get a complimentary consultation to learn if a 1031 or DST is right for you, I'm going to leave that poll up for just a bit. So thank you, K Properties. And in the meantime, I'm going to get our slideshow ready to go so you all can take a look. Although I think I might switch screens here just because I don't want to have my head turned the whole time. So let me switch over to this side. Here we go. That's better. Okay, let's see here. There it is. All right. So I'm going to go ahead and share my screen again. If you could let me know also in the chat if you can still see me and also the screen itself, that would be great. Let's see if this works. All right. How's that for you all? Can you see the presentation slides okay? Does the font or text look too small, or it's all okay? Okay. Thank you, Gabriella, Danielle in the chat. Awesome, awesome, awesome. So glad you guys are helping me out today. So Again, my name's Alexandra Alvarado, and I'm the Director of Education at AAOA. I've been here for over 10 years already, which is crazy. But it never ceases to surprise me how many developments we have in this industry. And can I just tell you, you may have to forgive me if there's any typos in this presentation, because I was literally updating it minutes before our presentation today, because there have been changes even in the last 24 hours. So all of this is really, I think, relevant right now. There are so many things happening in fair housing with HUD as well. So I'm going to cover a lot of that today, but I do encourage you to share this with other providers, housing providers you may know. But at the same time, because things are changing so quickly, I do want to disclose that this information could also change later. But this is what I have up to date so far for today. So before we start, I'm so curious as well. I'm going to launch one more poll question. Have you ever been sued by a tenant, right? So today we're talking about fair housing compliance. And one of the main reasons why is because nobody wants to get sued, right? We want to comply. Of course, we want to be fair in housing in general. But that's always, I think, in the back of our mind too, a little fear. Can we get sued? What do we need to do to check off those boxes? And with so many things changing, I think a lot of landlords are feeling a little confused, a little worried that they may not be doing everything right. So we're going to try to provide a little bit of clarity today. But to be honest, there isn't clarity on everything. And a lot of the time you will have to consult with an attorney to really see what they think is best. And even attorneys might disagree a little bit. So I'll leave that up for just another moment. And again, the disclaimer here is that I'm not an attorney. This isn't legal advice. Definitely use this for your educational purposes. I hope you walk away with this with lots of questions to ask your attorney if anything's different than what you're currently doing now. And always do that only if they approve, of course. So just a quick agenda here. We're going to go over some brief definitions, talk about the recent HUD guidance withdrawal from the Trump administration, the Fair Housing Act in general. We're going to go back a step, kind of take a look at what that is, just a refresher there, how you can set smart criteria that does abide by those laws, and what are some of the background check laws federally, but also at a state level that we should be looking at. And adverse action. What do you do when you do want to decline a tenant because you found a criminal or eviction record? And then a few more risk mitigation strategies, followed by Q&A. We may go over the hour mark as we usually do. I know you all have so many questions, but we will be sending everyone the recording. So if you do have to leave in an hour, that's okay. You can watch it back later. But if you can stay, I would love to take your questions at the end. I will email you the presentation slides and the recording tomorrow, so you don't have to worry about that. All right, so let's start with the act versus agency guidance. So essentially, let's start basic, okay? This might be too basic for some of you, but in case it's not, I wanna make sure we're all on the same page, because this is really the foundation of what we're gonna be talking about today. So an act is a statute. It's a law enacted by Congress, signed off by the president, whereas agency guidance is created by federal agencies such as HUD. So we have two different types of information. We should treat them differently, right? So agency guidance is non-binding. However, the statute or an act is legally binding. They both apply nationally. For example, the Fair Housing Act, right? That's going to be one of our main topics today. That is going to be really, I think, the main crux of what an act or statute is. You can ignore that eviction sentence there. I think that's a typo. And then on the right side here, we have HUD, which is now withdrawn. We'll talk about that in a moment. Their application of Fair Housing Act standards to the use of criminal records guidance. So think of an act as the foundation, the actual law that everyone must follow. That is all rental housing providers. And agency guidance is the instruction manual for how to follow that act. It tells you how that agency is interpreting and enforcing the law, but it is not itself the actual law. And I've said it in previous webinars that this HUD guidance has been treated like law. And I've even told you all to think of it like law and treat it that way as well. But now we're seeing some pushback to that. And we're going to talk about that in a moment and how that might change your processes. But really, people think HUD, maybe it doesn't apply to me. It does, it does apply to you. It isn't law, but it is really what is being used to interpret and enforce the law. So what happened just recently? I have a photo here of Trump with the new HUD secretary and essentially Scott Turner here. They have recently made some changes. I don't know if you've been to the HUD website lately, but it has this bright red message. This is a screenshot from their website that the radical left in Congress shut down the government and HUD will use available resources to help Americans in need. Along with this message, on September 17th, HUD essentially issued a notice of withdrawal of guidance documents. They withdrew the guidance. Now, that does include the application of Fair Housing Act standards for the use of criminal records by providers of housing, which is all of you on the call, and also real estate related transactions. So now we don't have those documents. You can't even access them on the site. I'm going to send them to you in the email tomorrow just so you have reference to them, because we'll go over this in a moment. Obviously, they're still relevant even though they're not on the site. So what does this withdrawal mean? Well, it means that HUD no longer supports or endorses the guidance documents. It means that there's going to be less clarity on how to apply criminal record policies because there is no guidance. And there are no new binding mandates. So that's the good news, because the guidance wasn't law to begin with. So it doesn't actually change the law in any way, but removing the guidance does remove that clarity that came with it. There's also going to be a little bit of a transition period, most likely, and uncertainty until HUD issues new guidance. They didn't say for sure that they would, but they said that they might issue new guidance. They also stated that they are, quote, deprioritizing enforcement for those who do not follow guidance, but it doesn't guarantee immunity from a fair housing challenge. You might think this is good news, but I'm going to show you that it may not be. It might sound great that HUD is no longer enforcing this as much, but we'll see why it might actually not be such a great thing in just a bit. So what is still being enforced? The Fair Housing Act. We know that's law. The law hasn't changed. And HUD's prior memoranda and notices may still be applicable for public housing, Section 8 or assisted programs. We know that those are usually governed a little differently. So if you have any Section 8 housing, just note that what we're going to be talking about today excludes that. There may be differences for Section 8 housing, and that would be probably a separate webinar, I think, at this point. So just keep that in mind. Also, state and local laws and court decisions continue to apply, and they actually might be more strict than federal law, which we see in a lot of different states. So they have their own laws that sort of go above and beyond what the Federal Fair Housing Act has dictated that we do as housing providers. Those still apply. Okay, what does this mean for you? Well, stay conservative. I mean, most of you are already with your fair housing friendly practices. If you're on this webinar, it's because you care about fair housing and keeping up to date and making sure you're following those rules. So just make sure that you're keeping those same conservative policies, even though the guidance has been withdrawn. And maintain documentation always showing that you're consistently applying all of these policies, and always be prepared to defend. I always say that. Think of yourself in a courtroom. I know it's probably not something you all want to do. It's not a nice thought to have, but if you were there, how would you defend your rationale? And monitor those HUD announcements and Federal Register notices. Like I was saying, even just in the last few days, there have been changes and updates. So as long as you're staying up to date on that, that's going to help you as well to make sure you're always in compliance. Also, instead of relying on that guidance that we had, even though I'm going to share it with you, just make sure that you're grounding your policies in the actual Fair Housing Act and other statutes and regulations and really what's best practice in our industry. And always, as mentioned, ensure compliance with those state and local laws and fair housing requirements that are really, I think at this point, going to be filling that gap that's left by the HUD's guidance withdrawal. So let's take a step back to Fair Housing Act. Another basic, some of you might think, I know what the Fair Housing Act is, but just in case you've forgotten some of the details, or perhaps you don't know it's your first time hearing about it, the Fair Housing Act is really, I mean, it's been decades, from 1968. It is federal. It does apply to all housing. There might be additional state requirements that apply. These are the protected classes. So we're familiar with these. This is what you don't ever want to imply at all in your interviews, in your selection process. These are the big protected classes that are federal. Now, states have added protected classes, so make sure to check your state. Other examples of additional protected classes might be gender identity, sexual orientation, income, criminal history, marital status. So just make sure you're checking to make sure you have all of those protected classes at the state level as well covered. And of course, this is enforced by HUD, but not only HUD, it's enforced actually by other state and local agencies as well, which we'll cover in a moment. So HUD announced on October 1st, 2025, that they will cut staff by 30%. That is quite a big cut, especially because they had already been cutting. So now there's less direct federal oversight. Who is actually enforcing those laws now? It's the local agencies and advocacy groups. Now, I listed some statistics here. Surprisingly, these statistics are from 2023. So this has kind of already been in the works, where we're seeing less cases handled by HUD and the DOJ and more cases handled by state and local fair housing assistance programs or nonprofit advocacy organizations. This is the breakdown here. Really, HUD and the DOJ only handled 6% of complaints that year. I couldn't find a more recent statistic. I'm sure it'll come out soon, but all that to say is that now HUD and the DOJ will be handling even fewer, but that means investigation and litigation is now coming from multiple directions, not just from Washington. So now we have to also be more aware of these local laws and local enforcement agencies that might want to test you, or tenants who may go through those routes rather than through a federal HUD or DOJ route. So another problem here is that HUD has really slowed down, right? We've seen the staff cuts already. Now it's going to be 30% less. That's really going to slow it down. And before, tenants could easily, I mean, real easily file for free a HUD complaint and start the process through HUD. And so there really wasn't a lot of barrier or loss of time or effort on their end to really do it. Now it's so slow that they're probably not going to bother to do it. So what are they going to do instead? Well, they're probably going to file lawsuits directly under the Fair Housing Act, which means plaintiff attorneys have stronger incentives to pursue private litigation. And guys, we don't want private litigation, okay? Lawsuits carry greater risks for property owners and managers, including a more costly legal defense, more reputational damage, potential for larger settlements or judgments. So like I said before, even though HUD isn't enforcing it as much, these other agencies are picking up the slack. And also now we have these private lawsuits as well that are coming into play. And I think a lot of attorneys are definitely going to be, pursuing that and asking their tenants to pursue it against their property owners. So things aren't really necessarily going to be any easier. I really just want you all to be aware of what this really means in the context of, your risk. So just a quick review here. When is the fair housing process or the Fair Housing Act considered? It's at every single stage of the rental process, even when they're your tenant. I mean, you really have to keep this in mind at all stages. Today, we're really only going to be talking a little bit about more of the criminal and eviction and background check process, you know, the part of where you're approving them for the rental. But I do encourage you to find other education and other ways to incorporate fair housing throughout your entire leasing process. Okay, another definition I want to go over as well that is pretty foundational to what we are discussing today. It says, I see you twice, written portion is very small. You know, I think I might go ahead and change my screen share type here real quick, if y'all don't mind. Let me just give it a pause and let me know if this might be a little better for you all. Let's see. Is this a little better? Can you see the screen a little larger? I don't know if you could still see me, but you might not really need to be honest. Let's see if you could tell me in the chat if it looks better. Okay, everyone says yes, yes, looks better. Great. Glad I checked the chat. All right, so disparate impact versus intentional discrimination. So what does this mean? Y'all have probably heard of it. Intentional discrimination is unequal treatment on purpose based on the protected class. So we went over what those classes are. It's pretty black and white. You're refusing to rent to a family because they have children or because they are a certain race or skin color or religion. Lots of, you know, examples I could give there, right? Disparate impact is a little harder to define. It's unintentional discrimination. It's a neutral policy, but it disproportionately harms a protected group. And this is where it's more likely for us to find ourselves, right? I'm sure all of you on the call aren't intentionally discriminating, but when you're unintentionally doing something that has an effect on a protected class, you are still just as legally liable. So a blanket ban on anyone with an eviction, for example, may impact certain racial groups more than others. I could say the same for criminal records as well. Both are illegal. So whether you know you're doing it or not is not an excuse. You really do need to look at how your policy will apply and affect all protected classes directly or indirectly, okay? And we'll talk about how to do that in a moment. So what do HUD and the courts really look at? Well, they're looking at whether the policy causes a significant adverse impact on a protected class. So they want to know if it's significant. I think that's a very important word there. And adverse, does it negatively impact them? And do you have a legitimate business justification for having that specific requirement or for asking that specific question on that application or for running that background check and credit report? You need to have that justification ready to go. And you also need to think about whether there is a less discriminatory alternative that would meet that same goal. So I know this is a different example, different topic, but I think it's relevant here. A common question we get with emotional support animals, for example, is, well, you know, what if my insurance drops me because I now accept a pit bull or whatever, right? A restricted breed. Well, then HUD would say, is there a less discriminatory alternative? Did you shop for other insurance policies, basically? So if there's a possibility that you could have the same, you know, effect, essentially, you meet the same goal, doing something differently, then you should at least show that you're trying to. So, for example, if you have a blanket criminal background ban that may unintentionally exclude a higher percentage of Black or Latino applicants, even if it's not your intent, that can still result in a fair housing violation. However, there is a way for you to look at criminal records in a way that is more individualized. So we're going to talk about that. And the individualized assessment would be a less discriminatory alternative where you're still giving people a chance and you're really individually assessing each record that you find against them, basically. So let's also look at setting SMART criteria real fast. So how do we set SMART criteria and why? Well, We want to save time. I think that's really probably the biggest case I can make for it is just, hey, if I tell my tenant ahead of time or the applicant, this is what I'm looking for, they may not apply, or they will apply depending on whether they think they will qualify, and that saves time. Makes it easier for you to choose. And I think this is so important. It really does make you stay objective and reduce that liability, so you don't look like have any sort of favoritism. And if you're treating everyone the same, then obviously that's going to be less discriminatory as well. I do want to point out California has a new law. I'm sure there are other states as well that may have something similar. So check your state, that you can't offer a non-refundable application fee if the written screening criteria are disclosed with the application. So just make sure you're taking a look at, any other additional laws. Here I have Minnesota, Washington, and Oregon that I saw have something sort of similar. There might be others. So whenever you see me mention certain states, just know that those are the ones that I've heard of, but that doesn't mean that those are the only ones that I know of or that are there. So some screening criteria, best practices. So I would say avoid including criteria related to criminal records. Don't require a social. Consider all types of income, not just employment. Keep everything consistent. You shouldn't make any one-off exceptions, but you can set a consistent additional requirement if they don't meet your criteria. So as long as you're consistently saying, hey, if you don't meet my criteria, here are your options. You can do lease guarantee. I need a guarantor or co-signer, or maybe I need additional documents like a W-2 or bank statement, or a higher security deposit, of course, within the limits of whatever your state allows. But as long as you apply those additional requirements the same in all situations, then that's fine too. So that's often something people get a little confused. So how do you set SMART criteria? You think of it as a scoring sheet, like a checklist, basically, like I have here. And so for every criteria they meet, they get a point or two. You can set up the points, and the tenant with the most points will be your most qualified applicant, or you have a minimum point threshold. Keep secure records of your scoring sheet for each applicant. I would say also put the date and time as well, because in California, now there is a new law of whoever's the first applicant and meets the criteria is the one that should be automatically offered the tenancy if you are going to charge them for the application. So keep that in mind as well. I think date and time is probably safe to say. It's a good idea for everyone here on this call to put whenever you have a call with a tenant, whenever they submit something to you, just mark when they gave it to you, so you have some sort of reference there and you can show that it was fair or that they applied before maybe a different applicant. So some examples here. The applicant has verifiable monthly income that is 3 times the monthly rent. This is a good example because it says verifiable. So it basically says that you are going to be checking, and if you cannot verify the income, then it won't count. And that's something that is allowed, as far as I know. And also, I put income. I didn't put income from a job or from a specific thing. It can be income from other sources as well. Social Security, it could be housing voucher, it could be retirement. So that is a better way to not discriminate on income. There are several states that have income discrimination laws. And so I think in general, though, it's probably safer to just consider income of any kind as long as you can verify it and it's obviously legal income. I put 3 times the monthly rent. That number is obviously going to vary depending on where your rental is located, whatever's realistic or whatever you feel comfortable with there. Also, that they don't have any considerable outstanding debts or rent-related collections in the past 12 months. 12 months, I just put that number, but you could make it more recent or make the time frame a little bit wider. Just be careful because, the more wide or the larger your time frame is, the more likely it is that you're going to be excluding a lot of your applicants. Also, you might want to say that they don't have any major delinquencies, or they have a minimum credit score of whatever credit score you want them to have, or that they don't have any unpaid judgments related to prior tenancies. that they don't have any lease violations or noise complaints, that the landlord references would rent to them again. It's great to call a landlord reference if you can get a hold of them, and that they didn't lie to you. I think that's fair. That they didn't cause damage exceeding the security deposit in their last, or maybe prior to that, their rental. But essentially, you can add more to this. This is just some of the examples to get you started. But whatever you put as your criteria, you need to be able to explain why it's necessary to protect your property or business interests. And, oops, let me go back there 1 second. Avoid any subjective language like trustworthy. Okay. So it should be just based on numbers, mostly facts here, right? And I would say even get together with your attorney, get a nice list of criteria going that is really customized to you and your risk tolerance, and also the Fair Housing Act, right? That would be that's the best way to do it, in my opinion. 3 times net or gross income, asked Paul. It's up to you. It's up to you what you want to do for that. I would say, another part is, if net is important, then maybe you go with net, but the number might be a little lower to kind of adjust for that. All right, so adverse action. Let's say now you don't want to rent to the tenant, okay? And you're a little worried about how you're going to break the news to them. Well, AAOA, if you're screening with us or with Tenant Alert, we include an adverse action or declination letter with your tenant screening report. So you can just print that and provide it to them. It has some check boxes that indicates the reason that you're declining them. It also has their rights under the Fair Credit Reporting Act and our information, so they can get in contact with us if they need to dispute anything. So what you want to do before you make that decision, right, is just make sure that you applied that criteria consistently, that if they didn't meet your criteria, that you're giving them that letter within a reasonable time. And note, they do have the right to request the report from the screening provider within 60 days, and they can dispute anything that is inaccurate. That number, 60 days, might be different in some states. So check your state laws. It might be a shorter time frame. Now, if you're taking adverse action due to a criminal record, I would say first contact the screening provider, make sure it's actually their record. I spoke with a tenant actually a couple weeks ago who had a criminal record that came up. Believe it or not, same date of birth, same exact name, first, middle, and last, same city they were living in for the last couple decades. And the record itself just didn't have a social available on it. And so we had to contact the court to make sure that it was really them and see if they could pull the social. And it wasn't actually his record. So just make sure that you're contacting your screening provider first, and your attorney, to, if it is in fact their record, to know exactly how to handle that process. And then again, check those additional laws in your state, because you might be required to give renters a chance to explain or dispute in a shorter time frame before you give them the letter. So there might even be a pre-adverse letter that you need to give them that opportunity. Okay, now let's talk background check laws. So we have federal background check laws. Essentially, the HUD guidelines, which I know they've been withdrawn, but they still are really guidelines that we can use here to at least give us a little bit of context. So past actions unrelated to tenancy and past incidents unlikely to recur should not be the basis for denials. They basically are saying here, hey, if they had a rough time because they lost their job, but they're otherwise have been very financially responsible, and that happened a long time ago, that's not, as important now, right? Maybe there is, a consideration you can give them if they do qualify today and, they fix their credit or whatever it was, you have some idea that here, they are actually now financially responsible. So just keep that in mind. Also, they did say in a recent guidance, also that has been withdrawn, is that AI and automatic screening tools could be unintentionally discriminatory. So that's just to say that if you have any tool that does any sort of automatic decline of the tenant, to not just take that and do whatever the system tells you to do, actually look at the report and make sure you follow, what your policies are. I know there's screening, and I think some accounts that might be on this call might have that feature where it tells you like a red, yellow, green light kind of thing. That's fine. You can use that as a guide, but don't just automatically defer to that without looking at the full report. Also, avoid any automatic exclusions. I think that's pretty straightforward. So automatic exclusions would be saying no criminal history, no evictions. That's very big, blanket, broad policy. So we want to avoid that. We don't want to overly rely on the credit history. Let's also look at some other ways of verifying financial income and stability. Again, this is guideline. I know I put laws. I should have changed that to guideline. My apologies. I'm going to change that in the PowerPoint when I give it to you all. These are really the guidelines that are coming with, this withdrawal, but it still is something to keep in mind, and to not use any criminal records or evictions that are old or irrelevant. Keep doing those individualized assessments, as I mentioned before. And of course, again, stay consistent. I'm going to repeat a lot of things on this webinar, but I think these are worth repeating because they are really so important. So now for criminal, we don't want to use a blanket ban, as I mentioned. Don't consider any arrests. So, we are innocent until proven guilty. So even if you find an arrest record, I know the temptation might be to say, oh, I don't want to rent to this person. But you can't use the arrest record. Ensure your look back period is consistent with state law. So most look back periods are going to be in the 7-year time frame, but there have been a lot of movements recently to reduce that look back period down to 5 years or even 3 years. So just make sure you're not considering any criminal records that are outside of that time frame. And if you do get a criminal hit and it is in that, appropriate look back period, you still want to do that individualized assessment of the nature and severity of the offense. So is it a crime that is actually harmful to people or property? When did it occur? Does it matter today so much if, there was something that occurred 7 years ago versus maybe 1 year ago? And have they had any evidence of rehabilitation or mitigating circumstances? So looking at, did they get a job? Did they start a family? Are they a different person now in some way? And is that offense even relevant to tenancy? For example, if you have a tenant who's applying and they have a DUI, maybe they were, very young and now they're in their 30s. I don't know that that's something that's really relevant today to their tenancy. So again, that wouldn't meet really a severe offense. It happened a long time ago. They have a stable job now, and it doesn't really apply to the tenancy so much. So think about it like that. Again, you want to look at each one individually and kind of go through these different questions and maybe even talk to the tenant about any sort of, evidence of that rehabilitation or mitigating circumstances. Okay, so now eviction. So narrow the look back period. So there isn't, again, this is guidance. I know it says laws, but the look back period typically, at least for us in our eviction records, has been 7 years. But many housing providers, they're now using shorter look back periods of 3 years, which is a little bit more defensible. And that aligns with those credit reporting limitations under the Fair Credit Reporting Act. So all that to say is that what they really want you to do is not look so much at evictions that are old, that happened a long time ago, or again, evictions caused by things that are not likely to happen again. So ensure that that look back period is consistent with state law, and also do that individualized assessment. Ask them to provide an explanation. Consider any mitigating circumstances like the job loss during COVID or domestic violence protections. California has a very new and also I think is very clear domestic violence protection now. So it's almost as if you have to automatically accept someone if they have a domestic violence issue. Court dismissal or sealing, that might also have been, part of it. Maybe you wouldn't have access to the record, but if you found out about it, then it's been sealed or dismissed in any way. That would be something you'd want to maybe not use. And also make sure you're always documenting your reasoning for approving or denying that applicant. Avoid the blanket language. Again, same thing with criminal, right? We want to avoid the blanket language. So instead of the applicant does not have a history of evictions, you could say something like, well, eviction history within the last X years may be considered and evaluated based on that nature, date, and circumstance of the eviction. You could use this similar kind of clause here. When you're thinking about criminal, I don't know that I would even mention criminal at all in the screening criteria, but this would be probably the best way to mention eviction in your screening criteria if you're going to put it in there. But I would say, again, talk to an attorney. Eviction and criminal, just putting that as criteria now could be looked at as, a little bit of a blanket denial. So you want to make sure you're, again, individualizing, looking at every single applicant and applying it consistently. So make sure, again, you're keeping those records and you're checking local laws. I mean, same thing with the criminal, right? As long as you're doing that process and you could show it and defend it, you're going to be okay. Most likely. It doesn't mean you're not going to be sued, but you're going to come out of it with a lot of evidence and likely won't be found at fault. Okay, so now let's go over some state laws. Okay, trending laws. So these are some places where you can't use most criminal records to deny an applicant. I think they make exceptions for sex offender records or some types of like distribution of illegal or manufacturing of illegal substances. But essentially, if your rental is in Oakland, Berkeley, Alameda County, Seattle, you can't really use criminal records at all. So keep that in mind. Check your state. Again, these aren't comprehensive lists. There might be another city or state out there that I don't know of that's not on this list. You can use criminal records, but only after an offer has been made. That happened in Cook County, Illinois, some time back. Essentially, you don't run the background check first. First, you run the credit report, eviction, identity verification, whatever reports you want, except for criminal. Then if they qualify, you give them an offer. Then you run criminal. And if there is a criminal record, you go through your process there and decide from there. Why they do this? They want you to give them a chance. They don't want you to necessarily, I guess, say no off the bat and instead look at all the other variables first. So to do that, they're basically forcing you to not look at criminal until you've looked at everything else. That's, again, something in Cook County, Illinois, might be now in other places too. I'm not sure. Limited look back period. So again, this is another common one I mentioned earlier. I saw this in Detroit, Michigan and Portland, Oregon, where they've done a separation for misdemeanors, which is interesting. So depending on if it's a misdemeanor or felony, the look back period might be different. Also, there's some no automatic exclusions in Minneapolis. Will this spread nationwide? Growing risk of lawsuits? Absolutely. So again, I'm sure, there might be other places that are already doing similar things. And every time you have these new layers of laws, that really does increase that risk of lawsuits if you're not also keeping up to date. Okay, so eviction state laws. So we have some trending state laws here on evictions. In California, you can't report evictions older than 7 years. As I mentioned, we only go back 7 years on our tenant screening. If you're doing your own search for whatever reason, just make sure you're not using anything beyond the 7 years. And just note that the pandemic era evictions have been sealed. So there isn't much you can do about that, right? There are some eviction records you just won't be able to access. And also in New York, there are some eviction records there you're never going to be able to see. And also in New York, it's a little ambiguous as to whether you can even use eviction records. I've talked to multiple attorneys about this and they don't all agree on whether the law allows you to or not. And so a lot of property managers have decided not to use eviction records at all in New York, which is a shame, but I do think that you should talk to your attorney that you trust and go with whatever they say if you are in New York. Also in Oregon, there are limits to the use of the prior eviction filings, especially if the tenant prevailed. So this is a trending sort of law as well, where if the tenant was found not guilty, you can't use the record. I think that's fair, right? I mean, we really only care if the tenant was evicted and, you know, was in fact, did in fact owe, you know, money. I think that seems fair to me. But anyway, these are the ones that I know of. Again, there might be more. So I'm going to stop here for a moment before we get into some risk mitigation tips. I see lots of things in the chat. You know, it really helped me out if you all could put it in the Q&A, just because it's easier for me to track. I know you can't see what I'm seeing, but in the Q&A, it's nice and organized. So it'll make it a lot easier here as well. So let me go ahead and start on some of these questions. Okay, Sam has a Section 8 question. Sam, I'm not going to cover Section 8 today, so I'll answer this one offline. All right. And that's the other one's an emotional support animal one, so I'm going to stop on that one. Okay, yes, Raphael, we will have the recording ready for you tomorrow for everyone. You're going to get an email tomorrow with the recording. Okay, Ari, so even saying no evictions within the last 2 years would be seen as disparate impact potentially, even though it speaks to their ability directly to pay rent currently. Never mind, you just answered this, that shortening the look back period in addressing circumstances can relate to this. Yeah, so again, you can use the eviction records, just be careful with, if you do get a record, how you're using it, right? That you're also considering all of these other circumstances around it. Also, Byron says, what is considered an old criminal offense? What if a prospect is still on parole or probation? Both are different. I would consult an attorney on this one. I mean, we're looking at the offense date. That's really what we're usually going, not the offense date, the judgment date. So whenever, you know, they were found guilty of that crime. So if that happened more than 7 years ago, that's usually considered old. And there's also some states that might extend it to 10 years, some that are reducing it, like I mentioned, down to 5 or 3 years. So what is old is really based on, you know, whatever your state says is that look back period. Or I would say, you know, what we do is we just do the 7-year by default. Okay, and Charles says, can I ask them if they have the move-in amount of money available currently? Yeah, that's fine. So you can ask them financials. You can ask them how much do you have available to pay for the security deposit and first month's rent. That's totally okay. You can put that in your criteria if you want. It might be, you know, sort of redundant, but you know, do you have the money to pay the application fee and you know, the background check and all that? Ari Bell says, in terms of criminal offenses, how do you handle when a child sex offender is applying to live in a community where children live? So most of these laws, as I mentioned, even the ones that are super restrictive in like Oakland, California, they do make exceptions for sex offenders. So again, check with an attorney if you do get a record like that. Obviously, you know, if children are living there, it's going to be a pretty clear-cut case as to why you wouldn't rent to them. So I would say it seems pretty defensible in my opinion, but an attorney would be able to better tell you exactly how to handle that situation. Tanya says, I think it's important to inform the attendees that HUD has nonprofit organizations called Fair Housing Initiative programs. Yes, I did mention that at the beginning, and they do assist individuals to file fair housing complaints and conduct investigations. Yes, and they are at no cost. That is correct, Tanya. I did cover that at the beginning. So again, we have the local agencies, the nonprofit organizations, and private litigation. So those are the 3 types of ways that tenants can pursue legal claims against you outside of going through a federal HUD or DOJ. Okay, Mohan says, can we not require the social security number in the application? So it depends. So there are some states now, several states that are actually saying that you can't discriminate based on citizenship status or immigration status. Now, indirectly, right, if you are requiring a social, you are in a way saying that if they don't have one, then they, can't have the rental. And that means if they don't have one, well, you're discriminating against their citizenship status, right? So check your local laws. I know it's California for sure. I have a list actually of some of the states. It's about like 14 or 15 different states. It's quite a few now that have specific rules around how to handle the social. Now, you don't necessarily need a social to do a background check. We could do it based off name and date of birth. For credit report, they can type in their own social when you invite them to apply through our platform. So you're not collecting it. We are technically. So if they feel comfortable with that, that's an option. Another option is instead of, requiring the social, you can still run their credit if you also go through an underwriting process where the credit bureaus come and they approve you, they inspect your office. It's a little bit of a, cumbersome sort of setup, but it does allow you, once they do that, to approve you to do the credit without a social, where neither you or the applicant would need to provide it. Let us know if you want to get set up that way. Also, Rodney says, what about denying tenancy to registered sex offenders? I already went over that, so I'm going to skip this one. And what if the tenant with an old eviction still has an open debt to the prior landlord? So so the debt itself, I think, if it's debt owed today, it's relevant today. So it's a little different than you're denying them because of the eviction. You're rather denying them because of the current debt, which is a bit different. But again, check with an attorney on that one, because I could see it kind of argued both ways. But typically, if it's on their credit report, for example, as a collection, and that's on there today, collections aren't going to be on the report for longer than like 7 years anyway. So you're probably in the okay time frame to use it, regardless. If otherwise, it would be hard for you to know, I guess, if the person owed a debt. I guess it depends on where you're getting the information from. So check with an attorney if it's outside of that 7-year time frame, I would say, just to be safe. Okay, I answered Carmen's questions. Can I run a background check without a social? So yes, you can if the tenant provides it, or if neither of you provide it, you'd have to just do that underwriting process. And Veronica says, what's the best way to reply to a prospective when they bring up that they have a felony or evictions on their records before any screening? So Veronica, if they're volunteering that information to you, you don't really need to say anything at all. Just let them know that you're going to still run the background check and that you will let them know your decision. And if you have your criteria, right, we did mention how you could state it for evictions, which is, we really are a Fair Housing Act, compliant organization, or I'm a Fair Housing Act compliant landlord. So I will evaluate everything according to the law. That would probably be a very neutral way to say it, not, oh, well, when did it, will I know? You don't need to ask more details. I would say just rely on the facts, the background check report, let them know that you're following the law and treating everyone consistently. David says the Trump administration, I heard Section 8 funding may be reduced or removed. What have you or others heard? Yeah, I mean, certainly it's on the table. I think reduction is more likely. It certainly will affect any of you here on the call who are heavily invested in that Section 8 funding. So we'll have to see. It's very speculative at this point, so it's hard to know exactly how it will come to be, I think. But it is on the table, so it's certainly something that is happening. And as I mentioned at the beginning of the presentation, all of this does not apply to Section 8. There's a whole other, some of it applies, I should say, but there are other laws that apply specifically to Section 8 housing. Okay, well, we received larger slides at the beginning portion when printed material was illegible. I'm sorry you guys couldn't read it and it was so small. Yes, you will at the, you'll get the slides separately and the recording too. I'll fix it so we can, all see what was happening. Also, can you avoid taking an application with an eviction record? So this is California, referencing the California law. If your first applicant meets all your criteria, except you as a landlord do not want to have to evict the applicant with a history of eviction, how should the landlord deny the applicant? Well, it would be based on how you're analyzing the eviction record. So again, how long ago did it happen? Have they made any efforts to, stabilize financially? Do they qualify on all other of your criteria? So it's really more about that. And a lot of times the answer is going to be, no, I don't want to rent to them still, even after considering all those factors. It's still a business risk. And if you can defend that in court, that it's a business risk to you, and you could show that it is, and why, then I think, if you have a strong case for it, then that's certainly an option for you. Now, you could deny them also if they, like I said, if they didn't have a good credit report, right? That would be a reason you could still deny them as well, not necessarily the eviction. But if everything else checks out and it's only the eviction, then you really have to make sure that you're looking at, whether or not it still makes sense to decline them. There is no hard rule. There's no law that says you cannot do this. So it does leave a little bit of ambiguity. I would say to just talk to an attorney if you're really unsure. But yeah, it really is going to come down to all the other aspects of the screening and their rehabilitation efforts and the circumstance of the eviction and how long ago it happened. Did they pay back that debt to the landlord? All those are factors to consider. Yeah, Ed, you can use an ITIN number instead of a social. That does work for a credit report. Thanks for bringing that up. An ITIN number is an individual taxpayer identification number that's provided to people before they get a social, has the same number of digits as a social, and they can use that to establish credit history. And we can use that to pull their credit report if they have one. David says, is there a site or software that picks up court cases for evictions in process and incarcerated in process or missed for applicants? I think there might be some typos there, but I'm going to go off the first part that you said, David, which is if there's a software that picks up court cases for evictions in process. I'm not aware of any, and you shouldn't be using court cases that are in process. So just like with criminal records, you're innocent until proven guilty. We do recommend the same for eviction as well. So there are, like I mentioned, some states that specifically say that you can't use an eviction where the tenant was found not guilty, right? But I would say also in general, using an eviction that hasn't been completed, it's not a closed case, is also going to set you up for some liability there because, it could go either way. So I would say it's better to stick to evictions that are case closed and we're in favor of the landlord. Okay, Kevin says, what about applicants who don't speak English if we can't communicate with them? That's a good question. I'm not too sure. I would say, to still be able to make some efforts to accommodate them would show that you are treating them as close to as the same as you can, right, as anyone else applying. But I don't know if there's any specific laws around that I'm aware of. I would say, again, to talk to an attorney about that if you do get someone who doesn't speak any English at all. Most of the time, though, they're going to have someone who's probably going to be able to communicate with you on their behalf, just to be able to have that conversation to begin with. Okay. Tanya says, oh, ETIN, says Ed. Oh, okay. So I talked about the ITIN, which is the individual taxpayer identification number, and ETIN is a business number that's used by the IRS. So you can run a business credit report if you're looking for that information using an ETIN. Otherwise, you can't use that for anything else. The business credit report would be, it's like a special product we offer, but it's basically, looking at the business's history of payments, not the individual. So that's what we would use an ETIN for, but we can't use it to pull personal. Tanya says, I think it's important to distinguish arrest records are not the same as convictions. Exactly. Yeah, Tanya, I did say that in my presentation. We absolutely, again, innocent until proven guilty. An arrest record doesn't mean anything really until it's an actual conviction. Rita says, sorry if this was answered. Why can't we use a social? So again, if there is a law in your state that says that you can't discriminate based on immigration or citizenship status, there are over a dozen states that have a law of that type, then you can't require a social security number. You could ask for it, but if you deny someone because they don't have a social, then you would be violating those state laws. And honestly, some attorneys say to not ask for it just to be on the safe side. But either way, like I said, if you do an application through us, we collect the social from the tenant. As far as speaking English or not, there's online translators to help you out. Absolutely. Google Translate is the best and it's free, right? So we can always make attempts here to try to communicate. Tony says, when an eviction is pending, can you insist on a rental reference from the evicting landlord? Sure, you can always ask for references. The evicting landlord may or may not want to give you one, but you can ask. May says, I recently had a problem tenant evicted, but the attorney did not file the memorandum as requested by the judge. Does that mean that the case is not closed? He has no forwarding. Ooh, you know, you might want to check online with the court. So if you go to the actual court website, most states and cities, counties, you can check the status of a specific case when you put in the case number. So I would say contact the court and see what they have as the case status. And it does take a little time to update too. So even like, you know, if it happened today, it wouldn't necessarily pull up in real time. It does take a little bit of a delay for the court system to catch up. Okay, so if you guys have questions that I haven't answered, it's because you didn't put it in the Q&A. So put your question in the Q&A. I'm going to do another round of questions in just a moment, and I'm going to continue here with the presentation. We're almost done. So let's talk about some risk mitigation tips. So first off is insurance, okay? This is going to be a great way to really cover any claims that are related to management decisions, and not just your management decisions. If you have a property manager as well, which I encourage you to share this presentation with them, you're really looking at, you know, fair housing complaints and lawsuits, screening and leasing disputes, wrongful eviction claims, any sort of misrepresentation or administrative errors. It's going to cover you for that. Also legal defense and settlements up to certain policy limits. So if you do manage multiple units or properties, which I think is almost everyone here on the call today, this is one of the most important types of policies that you can have. And everyone should know as well that not all E&O policies automatically include the fair housing defense. Just make sure that it does, okay? You don't want to find out the hard way that you don't have insurance to cover you, because you could do everything right and still have a fair housing complaint or a lawsuit. So that's why it's just so important for you to not only know the rules, but to also protect yourself, even if you are following the rules, because you never know. Also, there is separate fair housing and discrimination coverage as well. Some insurers do offer fair housing endorsements or specific coverage riders that go on top of your insurance policy. They're going to protect you against HUD complaints, disparate impact or discrimination claims, more settlement costs and legal fees. Definitely verify with your insurance agent or broker. So this is a little homework for you all. Make sure to go home today or tomorrow, look at your insurance policy or ask your insurance agent or broker, do I have discrimination claims? Are those included? Do I have E&O that includes that fair housing? Make sure it's on there. And also, if you're not sure, you're shopping around, or you think, oh gosh, it's going to be so expensive to add this on if you don't have it now, I do encourage you to visit our website here. I'll include this link in the follow-up email where you can speak with an insurance expert. We have a few that you can connect with, and they're brokers in the multifamily and rental property space. So it's not like your Allstate guy. They actually work with just landlords and property managers. So they'll be able to better assist you and make sure like you can shop around and know what your options are. Also, we do have a chat with an attorney page. So you can visit our legal chat page. I mentioned probably dozens of times that you should talk to your attorney. Now, a lot of you might not have an attorney on call because that's pretty expensive, right? So if you don't have one, like, you know, on call or on retainer or one that you work with regularly, you can at least sign up to chat with one. We have here a little chat with an attorney. You get assigned an attorney in your area. You can ask as many questions as you want online. So it's just basically like a little chat. They get back to you pretty quickly. I've used the service myself. They usually have really experienced attorneys. A lot of them are retired or, you know, they work from home. And so they have this kind of on the side, and they're pretty detailed and thorough with their answers. And the pricing is really unbeatable. I mean, for all the information I received, I just did the 7-day trial and I was like, I almost felt bad. I got so much out of it, but you can cancel at any time. So I canceled before my 7-day trial was over. So next time I go in, I'll probably pay for the month if I need it. But it's absolutely worth it to give that a try if you have a quick question and you really want to make sure like you have an attorney who's like telling you exactly the right answer. Well, to them, then this is a great resource. Also, tenant screening. I know we talked a lot about why, you know, you need to be careful with the records. I really want to emphasize though, that this doesn't remove the necessity of tenant screening. I really do think this is still one of the most important ways that you can reduce risk in general. And it is just important to make sure that you're still ordering that full credit report, eviction, and if it's allowed in your area, the criminal as well. I would say if you do get a social from the tenant, that you run an SSN fraud report, make sure it's really them. Now, again, we could run the SSN fraud report if they provide us the SSN through that application process. So even if you're not collecting it, you can still order it and get it verified. And technically the tenant would be giving us the social. So they might be more comfortable with that. Also, I encourage you to add a tax liens and civil judgments report. So this will catch any tax liens, which as far as I can tell in the fair housing laws that I've been reviewing, I don't see anything about denying someone for tax liens. So if they have a state or federal tax lien, that's not going to be on their credit report, but we do have a report in our premium package and also as an add-on that you can add tax liens to it and also civil judgments. And I believe it's only like a $5 add-on, which might be worth it. Civil judgments would include any sort of lawsuit other than eviction. So if they were sued for a different reason and they owe money to either their previous landlord or even to another entity, that's a huge financial liability and certainly could be justified as a reason that you would decline them. Also, manual county criminal searches. So we talked about criminal, right? And I will say most of you on the call today, like 90% of you, are probably getting instant criminal searches. Most tenant screening providers provide that, even if you're not using our system. However, there are now so many limitations in the data that is available in certain areas and states that even if you're allowed to do a criminal search, if you're using an instant search tool, it may not pick up records because those records just are very incomplete or maybe inaccessible on an instant basis. However, we are working on adding manual county criminal searches. We can do it now if you want to call us and order it, where we are actually going through the courts directly, and it does take a little time to get the results back, so it's not instant, but it would be the most accurate way to get a criminal search. And there are certain areas in the country, like I said, where those instant searches really aren't cutting it. And so I would say county is going to be the way to go for anyone in California. It seems to be going that way. We're getting just less and less information on the instant searches. So that means that what you would need to do is run a criminal search for each county. So basically we would go to each county and make sure we're getting the most up-to-date records manually. So more to come on that. I'll probably be announcing that via email, so keep an eye out when that's available. And you can always check AAOA.com, our tenant screening page. If you click tenant screening in the menu, if we do have that available, we'll be adding that there. So you can also check in on our website. And that's also where you can go to screen a tenant. So I encourage you again to keep screening. Just make sure you're doing it appropriately and that you are also consulting with, the attorneys and keeping up to date on all these new laws. All right, so if you are not a member of our association yet, you can go to AAOA.com to join for free. There are paid member levels as well if you want access to more things or discounted rates. But really, either way, if you're part of the organization, you can call us at any point. We'd love to help you out, answer your questions, or point you in the right direction. If you have a screening report that you're running, we can go with it. We can go through it with you line by line. So if you're trying to figure out how to read something, don't spend too much time. We can help you through it and tell you exactly what you need to look at on that credit report or background check. And we can also verify the record if you get one. So make sure to give us a call if you need to. My info is here as well. If you want to email me, I do make myself available if anyone wants to chat, or if you have a question you want to send me directly. So with all that said, I'm going to go over to the Q&A again. So one more time, if everyone put your questions in the Q&A, I'm going to be looking there about like another 10 minutes here, and then we'll log off. Okay. So does the FHA mean you cannot choose the best applicant financially, but you must choose the first one to meet criteria? I'm not in California. Okay, so Alexandra, if you're not in California, then the Fair Housing Act doesn't say that, basically. It's basically a California thing, and there's some other states too that might have that, where they're now, implementing state laws that are telling you, you have to choose the first one, or instead of batching all your applications and picking the one you like the most. But I will say that if you did have a fair housing claim against you and you do follow this California rule, they probably won't be able to say that it was wrong because it's so strict. You're really, really just limiting it to they came first, they applied first, they qualified first. There was no mention or thought of their race or religion or skin color. So it makes it, as you can see, a lot more clear cut that you would not have discriminated. So in that sense, it's helpful, but it's not required by the Fair Housing Act. But in some states it is. So I know it's a little confusing, but I think really it's really what you feel comfortable with. If you want to be really conservative, first come, first serve, first approved, first qualified is probably the way to go. Okay. Let's see. Okay. How do you handle verifying identity? We had a tenant who applied in his brother's name and social security. Yeah, so, what we do is we look up the social. We're looking at when the social was issued, the date of birth associated with it, all of the name variations, the status, the place it was issued in. That helps to kind of find out if it's, a sibling or a parent. But, they can get kind of sneaky. They can tell you also the brother's date of birth instead of their own. What I do suggest is collecting multiple forms of identity documentation. So not just, a driver's license, but maybe also let's look at your W-2. Let's look at your, utility bills. Let's look at your renter's insurance. There are many other documents that have the ability for you to verify identity. And I know I was mentioning earlier and all that we can't necessarily require a social, but you can require any sort of government issued identification. So passport would work, some kind of ID, right? And even though we don't yet have a software, and I'm not aware of one that would be able to tell you if the document they gave you is real, we can at least, by asking for more types of documentation, make it harder for them to keep it all consistent. And ultimately, when you get the report back, there also might be some inconsistencies. For example, if we can't find a previous address history based on the person's name and social, that's a mismatch. That's a problem. If we can't find their credit report, there's probably a mismatch. If the date of birth on the credit report doesn't match the date of birth they gave you or the date of birth on the social security number verification report, that's a red flag. So there are some indirect ways that you can tell, but it's not so easy as, yes, this is real and this is not. So my suggestion is always to collect multiple forms of identity verification, make sure everything matches across the board, and let us know if you think you have any inconsistencies. We can look into it a little bit more. How does your screening report differ from Zillow's? So Zillow's using TransUnion that I'm aware of for their background and credit report. We actually use more than just TransUnion. We also use Experian, and we also use court databases. We use all kinds of databases for the previous address history report. So we're able to find more data than just what TransUnion has. And because of that, we have an extremely high rate of finding eviction records because we're able to locate so many addresses, and we can cross-reference that and pull up, in many cases, I've heard our landlord members tell us that we found evictions that were not found on their software. So it's more detailed. We have more report options. Zillow also doesn't have tax liens or bankruptcies, as I mentioned. They don't do the landlord or employment verifications. So we do that. We do phone calls outbound to verify a previous landlord or employer. Lots of things that I didn't cover in this presentation today, but our screening is more comprehensive. We really do have many more options. And I think the best part is that we actually have someone you can talk to. And you might even get me on the phone. So we all answer the phone here. We will go over it with you line by line. You would be hard pressed to find someone, an actual human that you can talk to at a big company like Zillow. Jay says, can you ask a copy of the driver's license because it has a picture? Yeah, you certainly can. As far as I know, asking for any kind of government issued ID, like a driver's license or a passport that has a picture, is allowed. And again, it's not to say that they couldn't have altered it, right? But it just gets harder and harder for them to do, I think, as you ask for more and more documentation. But that's a good point. You can definitely get that picture there. And what's interesting as well, I will mention, so some sex offender records, they come with a picture. That's another thing that is actually, I wish they did it for all criminal records, to be honest, but that is really helpful when you get one of those. Jessica says a good business practice is to wait until the application has been approved before asking for the photo ID. Oh, Jessica, if you could tell me why that is a good practice, I'd love to know. I haven't heard that that's a better order to do it. Is it because if they don't know that they're going to be asked for the photo ID, they might have lied to you on the application? That might be it. David says a federal ID altered is a federal crime. Yeah, I mean, it is identity fraud, right? That's essentially what tenants are doing. That one example where a tenant was using their brother's social, that's fraud. So good point. People think of it very casually. I think tenants do. And it is much more serious than they believe. Rodney says, we found it helpful to supplement background screening with Google and social media searches. So I would say that's not a bad idea, right? I like checking on social media for employment status. Go to LinkedIn, make sure it's a real company. Do they work there? Most people have LinkedIn. It's not like a for sure, if it's not there that they're lying to you, but it's nice to see that, right? It's nice to see that if you're doing a Google search, nothing crazy comes up. But just be careful on, if you're collecting this information, what you're actually going to use to decline them. Just make sure that it's all, information you can legally use to decline them. So if you find something, maybe run it by your attorney and say, hey, can I use this as a reason to decline them? Or should I use a different reason? Maybe that is more Fair Housing Act compliant, right? Okay, Rita says, can you ask or require the tenant to advise or confirm changes in employment? Yeah, employment is fine. So again, in some states where you can't discriminate based on source of income, you can't require them to have employment. But if they are stating that they are employed, then you can certainly ask them to confirm any changes. At least renewal is a good time to do that. Or when they're, applying, you can call the employer. Like I mentioned, we can call the employer on your behalf as well if you'd like. And most employers, they're going to tell you, yeah, they work here, or, they don't. Some will tell you how much they make, which is really nice when they can, or they might refer you to a third party that'll confirm the information and you have to pay the third party. But there's usually a way to confirm it other than just asking the tenant as well. Or if the tenant moved recently, they might have a letter maybe with an offer. That might also be nice. Jay says, any word about safeguarding tenant data, locked filing cabinet? Yeah, locked filing cabinet is great. I mean, really, you're looking at making sure that if you have, I think really the issue is not someone breaking into your house and stealing all your applications. The modern day issue is accidentally emailing something you shouldn't have and your email getting hacked, right? Or keeping data on your computer that gets hacked. So just make sure that if you are, doing anything online with that really important data, that you're just being super cautious with it. Never email anyone's social back and forth. Password protected PDFs are good. Looking at like mailing them a letter or keeping those, reports printed and in a locked filing cabinet. By the way, our reports, and as well as all screening reports, they expire. So they might not be online if you need to reference them in the future. Our expiration is 90 days. So print them, keep them in that locked filing cabinet. And, unless someone breaks into your house and they break the cabinet and, it just seems like it's a lot harder, right? You're doing more steps here to keep it safe. So I think that's a good idea. Yep. Mike says every state has a sex offender database that shows the names, addresses, photos, and crimes. Yep. That's definitely something you can check. We include the sex offender automatically. We do check all 50 states at once for you, so you don't have to go state by state. But certainly it does have all of those details, which is really nice. Helps you make sure it's really them. Oh, Jessica's explaining why she gets the ID after they complete the application process. And she says it's because if you get the ID prior to completing the application process and you then decline the application, you may have a challenge saying you didn't discriminate against their race or gender from the photo ID. I see. And if you decline the app and you never received a photo ID, you are in a stronger position to say you weren't discriminating in your application process because you didn't know the race or gender at the time of declining the app. So that, Jessica, that's a great idea. I mean, it works if you haven't met the person in person, right? I think that's it. I hadn't thought about that. I'll add that to my presentation as a tip. Certainly wouldn't hurt if you haven't met them. I suppose there is no way for them to say that you discriminated based on what they look like. Great point. Okay, David says, what I found about someone who doesn't speak English, I required them to bring a translator, and then I have the translator sign the document that they were hired by the applicant. This has worked for the Massachusetts court system, which is very strict. So that's a great tip, David. Having that translator show that like they were present and they explained everything. I think that's a nice way to make sure you're treating everyone the same, kind of giving them all an opportunity there. So again, if you all have any sort of, let's see, Ari says PayScore does the online ID verification and digital confirmation that the person on the ID is the person in real life. That's great, Ari. I've heard of PayScore, and I had thought that they didn't work so much with smaller landlords, but if they do, that's a great alternative as well. Okay, so do all these rules and guidelines apply equally to market rate versus affordable housing, single family to multi-tenant? So this applies for any type of rental housing except for Section 8. So I covered rules that would apply if you have a single family or multi-tenant. It really is going to be just the Section 8 that's going to have potentially more rules or different rules than what I did here. Oh, Ari says you can do a la carte very cheaply. That's great. That's great. Great tip there. Okay, so I think this really covers it. I know there's some more comments in the chat that I might have missed, but again, if you have questions that I didn't answer, you can always go to my email here and send me a quick message and I'll get back to you. And again, tomorrow we are going to be sending you the full recording and the slides, so you'll be able to take a look at that and review it at your own pace. And of course, again, I'll include those resources. So like the chat with the attorney, the HUD guidance documents, and any other, links there that I might find helpful for you to have. I hope you'll also join us for our next webinar next week. It is going to be about 1031 exchanges. And then also you'll get an invite for that in the coming week or so. I hope you all learned something today, and I hope I didn't confuse you all too much. I know it's quite a complicated topic, and I'm really just trying to stay up to date as well with everything that's going on. And we'll have more of these in the future, so stay tuned and keep an eye out for those webinars as things develop. I'm sure I'll have another one at the beginning of the year that I'll do. And then we're also having a New York specific legal webinar in December. So if you're in New York, definitely go to that one. New York is like, whew, you thought we talked about a lot of laws today. There's even more that we didn't cover that apply to New York. All right, everyone. Thank you so much for sticking around. We'll see you again soon. Bye.